In the name of God, the compassionate, the merciful. Welcome, friends, to the 51st episode of Crime and Punishment, a legal podcast, not a political one. This is the official podcast of the Invictus Law Firm, PA, a criminal defense law firm in Orlando, Florida, the website for which is augustusinvictus.com. That is me, yours truly, the host of this program. In today's news, we have gun control measures by Congress. We have the show trials for the J6 defendants. We have another $1 billion or so going to Ukraine, I'm sure. We have artificial intelligence at Google that has become sentient. A lot of good things going on in the news, and that all concerns the law. But we're not going to talk about any of that. We're, in fact, not going to talk about anything that's happened in the last 1,000 years or so. We are instead going to continue our discussion of the nomos of the earth, the text by Carl Schmitt. Now, usually, my technical problem is that I can't pull up the newsletter and the viral style and all that. Today, the problem is that I didn't pull up the chat. So, as a matter of fact, I'm just checking to see if the sound is all good, making sure that the program is running. All right. Program's definitely running. Richard's first. Welcome, Richard. Let's go to the links here for the viral style and the newsletter. How about that? Which we actually published today. Anybody who is interested in being the social media guy, posting all this stuff, newsletters, all that, please do let me know. Richard and Florida Man both say the sound is on. That's good. So there's the link to the newsletter. Here's the link to the viral style right here. If anybody wants to do this and get paid for it, please do let me know, because I really don't like doing this. All right. Let's see what other announcements I've got to make. I think that's pretty much it. We are simulcasting to Twitch, DLive, Twitter, YouTube, LinkedIn. Please do subscribe to the newsletter so you can get the updates through there. Please also subscribe to YouTube if you're not already listening to us there, because that's the most dependable source for this program. Now, we've talked for the past couple weeks. Last week we were not here. I had business elsewhere outside of Florida. So we didn't do the show last week, but for the 2 weeks prior to that, we discussed international law. We discussed the nomos of the earth, the international order as we understand it today. We discussed the creation of the present international order. This was developed out of Bretton Woods. This was developed on the back of World War II. The closing of World War II put the United States and the Soviet Union at the top. We brought in Britain, France, and China, and the 5 of those powers make the United Nations Security Council with veto power. We've discussed how much that really means. Like, the powers at the top, they don't actually consult the Security Council if they know they're going to get a no. So we discussed all of that in episodes 49 and 50. Today, we're going to go to the actually interesting stuff, or at least start the actual interesting stuff. Today, we're going to start with pre-global international law. That's chapter 2. I don't know if we'll have time, but chapter 3 is titled References to International Law in the Christian Middle Ages. So pre-global international law includes basically everything before we developed a conception of the globe, right? Before the discovery of the New World, before Magellan circumnavigated the entire globe, we have pre-global conceptions of international law. So the first chapter, pre-global international law, is probably more accurately titled Ancient International Law. And then he goes into the Christian Middle Ages, before the discovery of the New World, to discuss the fact that after the New World is discovered and we now have the concept of one total Earth that has bounds now, Well, this Christian Middle Ages conception of international law is what the New World Order was based on. So he's going to give us the historical progression of international law from ancient times through the Christian Middle Ages to the present day. Well, present day in 1950, but that's basically where we're at now, is the 1950 conception of the international order. So, let's nerd out. For centuries, humanity had a mythical image of the earth, but no scientific understanding of it as a whole. There was no concept of a planet, of human compass and orientation common to all peoples. In this sense, there was no global consciousness, and thus no political goal oriented to a common hope. Thus, a jus gentium, international law, capable of encompassing the whole earth and all humanity, was impossible. If one speaks of a jus gentium in this age, it is only in terms of differing spatial structures, but not in terms of what later, after the emergence of planetary and global concepts, was called the law of nations, jus gentium, or international law. In this context, we can disregard the philosophical generalizations of the Hellenistic period, which made a cosmopolis, or a world state, out of a polis, or city-state, because they lacked a topos, or orientation, and thus had no concrete order. In other words, they were reasoning about the world state from the concept of a city-state, right? So let's say you have no conception of the outside world. You have never left your home, right? The only social organization you know is your family. So you are going to reason out to say, well, a city would be this because we're conceiving it based on our family structure, right? And reasoning further out from that, well, we can imagine what a nation state would be based on our conception of the family here at home. And you keep reasoning out until you got to a world state, right? That's what he's saying is they had a polis, the city-state, in the Hellenistic era in Greece. And they would reason out abstractly, well, this is what a world state would look like. But they had no actual concept of what the world was. They have no concept of a globe. There was no spatial ordering that said we are all on this planet and these are the bounds and this is what a total political state would look like. It was all just basically reasoned out. It was deduced from that conception of what they did know in the city-state. If we consider the Earth retrospectively, from the horizon of today, naturally it always was divided in some way, even if men were not aware of the division. But this was no spatial ordering of the earth as a whole, no nomos of the earth in the true sense. A variety of great power complexes, the Egyptian, the Asiatic, the Hellenistic empires, the Roman Empire, perhaps even Negro empires in Africa, and Incan empires in America, in no sense were disconnected and totally isolated from one another. But their interconnections lacked a global character. Each considered itself to be the world, at least the world inhabited by human beings, or to be the center of the world, the cosmos, the house, and each regarded the part of the earth outside this world, as long as it did not appear to be threatening, to be either uninteresting or an odd curiosity. To the extent that this outside world was threatening, it was thought to be a malevolent chaos, in any case, to be an open and unoccupied space free for conquest, territorial acquisition, and colonization. However, this situation was not at all as it appears in 19th century textbooks, or as the Romans saw it according to the renowned scholar of Roman history, Theodore Mommsen, that is, that the peoples of antiquity coexisted in a situation of natural enmity, that every foreigner was an enemy, and every war a war of annihilation, that all foreign territory was enemy territory unless an explicit treaty of friendship had been concluded. And all this because there was as yet no international law in the modern, humane, and civilized sense. Such claims are indicative of the self-confidence of the 19th century and its civilizing illusions. In the meantime, they have found verification in the world wars of the 20th century. What a mouthful. That's all just one paragraph, by the way. So, what he talks about a lot is spatial ordering, spatial concepts, saying that all law is tied to the earth in a very real sense, the soil itself, boundary markers in the earth, right? And this goes back to his distinction between the land and the sea. So he's saying, as we've talked about in previous episodes, that there is no abstract concept of law out there in the ether that we're trying to reason from. Law actually comes from the earth itself. When he's talking about the spatial ordering, we're talking about pre-global international law, because now that we have a globe and we know our place in relation to the sun, allegedly, now we have this concept that, well, Orlando's a city, Washington, D.C. is a city, London's a city. None of these is the center of the world. It might be the center of my life here in Orlando, but I'm very aware of the fact that there is a world and Orlando is in this particular place on the map, and everything else is just, those are cities in different places. That was not the conception of the world in ancient times. In ancient times, there was no globe. There was, this is our land. This is, say, Teutonic Germany, right? This is the soil where we live, where our ancestors were. This is where our ancestors were buried. These are the lands that we have conquered. These are our enemies' lands. Everything outside of here, well, that's just the vast unknown, right? Or in Greece, this is civilization. This is Hellenic civilization. Anybody outside of here is a barbarian. And the Romans were the same way. There is the Roman Empire. Everybody outside of those lines drawn by the emperor, those are barbarians. They are unconquered territories that we're going to conquer. Not by divine right, not by some civilizing mission, as we white folk used to have under the British monarchy. Nothing like that. It's just, that's life. You have the empire, you expand it. You have territory, you expand it. And that was the spatial conception. Where we are is the center of the earth, and everything outside of that is either uninhabitable, wilderness, some place of strange things like Gorgons or Hades, or peoples to be conquered. That was the spatial conception, and that's the very important distinction that he's making between ancient times and today, between the ancient consciousness and modern consciousness, and of course between pre-global international law and the international order as we understand it today. Contrary to these incorrect claims, now that's another thing we didn't point out in the past paragraph. I said there was a lot to unpack in that one paragraph. The other is he's talking about, his name is Theodore Mommsen, it doesn't matter, any scholar. Schmidt is famously dismissive of modern scholarship, and by modern we mean anything post-Middle Ages. I've mentioned before, he is basically a medieval Catholic thinker. Theodore Mommsen, scholar of Roman history, well, the ancient world was nothing but enmity. Kind of like, ironically, Hobbes would say, without the Leviathan, life is nasty, brutish, and short. And Schmidt is famously a Hobbesian thinker. But this scholar of Roman history, he's saying, before our civilized European world structure, ancient peoples were just in a constant state of war. And even your neighbors you were at war with because they didn't have our civilized manners and our concepts of international law, which are so enlightened. And Schmidt is saying, yeah, that's ridiculous. This is indicative of 19th century prejudice and what he calls its civilizing illusions. So clearly he disagrees with those scholars. He disagrees with, like I said, pretty much all modern scholarship. So he says, contrary to these incorrect claims, the historically correct realization has gained acceptance. That is, that precisely Roman law, in its practice of international law, recognized a variety of wars, leagues, federations, both equitable federation and inequitable federation, and foreign territories. Above all, Roman law was able to distinguish the enemy, the hostis, from the thief and the criminal, as is evident in Pomponius' often cited axiom that, quote, there are enemies who declare war against us, or against whom we publicly declare war. Others are robbers or brigands. So this goes back to what we were talking about, I believe, the first class, about piracy, right? There are criminals on land, because on land you have an actual order of things. You have laws, you have structure. The sea was historically a no man's land, and piracy was not just tolerated, but actually glorified. As we pointed out, Odysseus was a pirate, right? You, like a Viking, you go up on shore, you raid the land, you steal their women and their treasure, and you're a hero for it. What he's saying is, Roman law understood these same distinctions that we understand, that there's a difference between a public enemy with whom you go to war and someone like a criminal, a robber, a brigand, someone that you punish under domestic law. The ability to recognize a justus hostis, just enemy, is the beginning of all international law. Thus, there was an international law corresponding to the pre-global image of the world, but its concepts of the world and of its peoples remained in the mythical sphere. These concepts could not withstand the geographical enlightenment and scientific measurement that prevailed in the global image of the world after the 16th century. The earth, or the world, appeared to be a circle, an orbis, although the ambiguous word orb can signify a disk, a circular surface, as well as a spherical body. Its boundaries were determined by mythical concepts, such as the ocean, the Midgard serpent, or the Pillars of Hercules. Its political security rested on exclusionary defensive structures such as border fortifications, a great wall, a limes. According to Islamic law, the concept of the house of peace outside these defenses was war. So, a lot of things to unpack there. Let's talk first about the very first sentence we read. The ability to recognize a justus hostis, just enemy, is the beginning of all international law. What Schmidt is most famous for, I think, is his concept of the political. He breaks down the politics into the distinction between the friend and the enemy. That is it. That is all politics is. All this talk about the Whigs and the Tories and the Republicans and Democrats and the communists and the anarchists and the fascists, voting or monarchy or whatever, all of that is garbage. It's all just, lace and doilies. It's smoke and mirrors. Politics, all in the final analysis, comes down to friend or enemy. He makes the analogy to beauty. Beauty is either, or art rather, it's either beautiful, aesthetics, not art. Aesthetics is either beauty or ugliness, right? It comes down to those simple distinctions, very elemental. So politics is this life and death struggle. And it's groups of people, it's tribes, it's nations, right? It's that life and death struggle for resources. Who is your friend? Who are your allies, right? Who are the people with whom you're allied? Who are the people that you're fighting for? And on the other side, who are the enemies? Who are the people with whom you're struggling against for those limited resources? So he brings that conception here. The ability to recognize a just enemy is the beginning of all international law. He also famously made this distinction about the difference between a personal enemy and a public enemy. As I said, he's Catholic. There is always the rebuttal to any talk about war, especially by the Quakers, right? Or some pacifist organization where, well, didn't Christ say to turn the other cheek? And Now, war is immoral and all this, but Schmidt is the one who pointed out there's a difference between a personal enemy and a public enemy. When Christ is talking about turning the other cheek, forgiving your enemy, so on and so forth, he's not talking about nation states. He's talking about your personal enemies. He's talking about your moral obligation as a human being to forgive your enemies, to turn the other cheek. When it comes to war, we're talking about the laws of war. We're talking about international law. So there's a distinction between that personal enemy and the justus hostis, the just enemy, which is the beginning of all international law, as he says here. So that's one part to unpack. He's talking about the mythical concepts of the ancient world and how they determine the spatial order and therefore pre-global international law. He points out the Midgard serpent. I'm sure you probably know what that is already. Jormungandr was said to encircle the earth. The Pillars of Hercules, that is the entry to the Mediterranean or going out of the Mediterranean to the Atlantic Ocean. And then Islamic law. This is an interesting one that I wish he would have expanded upon. The concept of the house of peace. I like this concept of Islamic law. I think it's a very interesting way of looking at the world. I'd say there's probably a Christian corollary there, in that there is the Christian world and there's everything outside of it, right? But in Islamic law, there is the house of peace, which means you're in an Islamic country. And outside of a Muslim rule, that is a house of war, right? So he's saying that there are these concepts of the border fortifications, the house of peace in Islam. And outside of these defenses, outside of these borders, there is war. The purpose of such boundaries was to separate a pacified order from a quarrelsome disorder. A cosmos from a chaos, a house from a non-house, an enclosure from the wilderness. Boundaries constituted a division in terms of international law, whereas in the 18th and 19th century, for example, the border between two territorial states of modern European international law did not constitute an exclusion, but rather mutual recognition, above all of the fact that neighboring soil beyond the border was sovereign territory. So, that's a huge distinction to make between ancient conceptions of law and modern conceptions of law. You could also point out that distinction in between natural law and positivism, right? When you see articles by just anyone, just throw a dart and you'll hit the Wall Street Journal, CNN, MSNBC, they're all the same. They'll publish this article, well, 67% of Catholics believe that abortion should be legal, right? Or 87% of Americans believe that homosexuals should be allowed to marry and adopt children. Really, who cares? Unless you are of the persuasion that law is nothing but an agreement by people. And so law is nothing but basically the whims of the populace. We all just agree that this is the case, right? So what Schmidt is saying is there's a difference between the ancient conception of law where here are the borders we have made, or that the gods have made, right? And that we understand the world to be. This is Jormungandr, who is encircling the world, and outside of that is chaos. Here is the border fortification of our city-state, and outside of that is the wilderness and hostile peoples. Or here is the line of our kingdom, or here is the seashore, and out there is the sea, and there is no law. Take that concept and contrast it with, we are the French and German ambassadors. We are coming together to agree on this treaty. And we agree that the border between Germany and France will be drawn thusly. Completely different conception of boundaries, of nation states, of what international law means. So, in all ages, there have been relations between empires, various negotiations and engagements, both friendly and hostile, legations, trade agreements, safe conduct agreements, alliances, wars, armistices, peace treaties, family relations, rights of asylum, extraditions, and hostages. In all ages, he says. So this thing about asylum seekers or refugees, extraditions for being brought to trial in a different state or country, family relations, treaties, none of this is new. Modern scholars would have you believe that it's new. He's quoting, 18th, 19th, 20th century scholars. Every 21st century scholar believes that everything we're doing is brand new. We are so clever. We have come up with all of these things. We are so enlightened. We now have these statute books and we are developing the law. Thank God. Thank God for Bretton Woods. Thank God for modern positivism. But no, all ages, we've had these things. This is the human condition. When I was in law school, I did an independent study with a professor I will not name. The professor used to work at the Pentagon. Super brilliant guy in international law. That's obviously what my focus is on in law school. Did this independent study, and the first thing he made me read was Thucydides, the Peloponnesian War. The entire independent study was on realpolitik in international relations, right? And the first thing you realize when you read the Peloponnesian War is this has all happened before. Everything that you think is new, everything in the Ukraine-Russia conflict, everything in, NATO or NAFTA, everything in the war between Texas and Mexico, the Aaron Burr treason trial, Genghis Khan, whatever you think is new under the sun, it's not. It's not. Everything you know about politics is in the Peloponnesian War by Thucydides. And we're just all reliving this cycle for centuries and millennia. One of the biggest things that came up in that independent study, which I'm sure this happened throughout the Cold War, is that the conflict between Sparta and Athens is largely reflected in the conflict between the United States and the Soviet Union throughout the Cold War. Absolutely nothing new. Absolutely nothing new. And the United States was, of course, Athens in the war, and the Soviet Union was Sparta. So, what Schmidt is pointing out here is that in all ages, he says, there are negotiations, safe conduct agreements, alliances, wars, armistices, family relations, rights of asylum, extraditions, hostages, all of this that you think is new. It's not new. They had it in ancient Rome. They had it in Assyria and Babylon. They had it in China in ancient times. This is the world. This is human relations. There was commercium, commerce, and often even connubium, marriage, at least among the ruling families and groups. Let's point out something there since y'all have come to class today. I didn't know this actually until my 30s. There is a difference between ecclesiastical Latin and classical Latin. So you get a bonus lesson today. It's not technically part of international law. So classical Latin is what we think of with Cicero, Seneca, the days of Caesar and all that. And it's pronounced in one way: hard C's, hard G's. Ecclesiastical Latin is the Latin of the Catholic Church. So it's just easier to say. It's closer to Italian, right? So commercium would be ecclesiastical Latin pronunciation. Commercium would be how you pronounce it in classical Latin. Just a little tidbit for you, just extra credit. The first treaty of peace, friendship, and alliance handed down to us in the original documents of both parties dates from 1279 BC. It is the much-discussed treaty of the Egyptian king Ramses II with Hattushilish III, king of the Hittites. The treaty contains provisions covering mutual aid against domestic and foreign enemies, extradition of refugees and emigrants, and amnesties. It has become famous as a model treaty of international law, and is also an example of the founding of a dual hegemony of two empires. Until recently, it was commonly thought in Europe that fully developed diplomatic exchange and the art of a well-conceived foreign policy balancing several powers first arose in Italy during the 15th and 16th centuries AD, as a highly modern product of the Renaissance. Today, this view is described by experts on Egyptian history as an illusion. The negotiations, alliances, trade agreements, political marriages, correspondence, and archival systems of the pharaohs, the kings of Babylon and Assyria, of the Mitanni and the Klati in the 14th and 15th centuries BC, are seen now by some historians as prototypical relations of international law. The political and economic relations of Greek, Hellenistic, Jewish, Indian, Arabic, Mongolian, Byzantine, and other power formations are often the subject of interesting studies. Nevertheless, all that was only jus gentium, or international law, in an incomplete and indeterminate sense. Not only did everything, war in particular, remain organizationally at the technological, economic, and communicational level of that time, but, above all and most decisive, everything remained within the framework and the horizon of a spatial concept of the Earth that was neither global nor all-encompassing, of an Earth that had not been measured scientifically. All the great political power complexes that emerged in the high cultural areas of antiquity and the Middle Ages, in both the Orient and the Occident, were either purely continental cultures, river Potomac cultures, or at most inland sea cultures. Consequently, the nomos of their spatial order was not determined either by the antithesis of land and sea as two orders, as in traditional European international law, or, still less, by an overcoming of this antithesis. That was true for the East Asian and Indian empires, as well as for the Oriental empires until their reshaping under Islam. It also was true of the empire of Alexander the Great, of the Roman and Byzantine empires, of the Frankish empire of Charlemagne, and of the Roman Empire of the German kings of the Middle Ages, as well of all their mutual relationships. As for the feudal law of the European Middle Ages in particular, it was land law in the sense of an exclusively terrestrial order not acquainted with the sea. Papal awards of new missionary regions divided the spaces of land and sea equally, without distinguishing between them. The papacy raised claims to all islands, Sicily, Sardinia, Corsica, England, but these claims had reference to the alleged donation of Constantine, rather than to a division of the earth based on land and sea. The antithesis of land and sea as an antithesis of diverse spatial orders is a modern phenomenon. It governed the structure of European international law only after the 17th and 18th centuries, that is, only after the oceans had opened up and the first global image of the earth had emerged. So, while there is nothing new under the sun concerning treaties, safe conduct agreements, hostages, war, so on and so forth, what is new is the spatial ordering of human consciousness. This notion that we live on a globe that is complete with bounds. And it wasn't until the 17th and 18th centuries, after the oceans had opened up, that this first global image appeared. After Magellan circumnavigated the Earth, it was proved that you could make it all the way around. That is when we started understanding that the world, or the our conception of where humans could live, it was not boundless or infinite. The common law that arose from such a pre-global division of the earth. That reminds me of something that I meant to address. I was reading about Charlemagne. I was reading a biography of Charlemagne earlier this week, and it was talking about his development of the common law. I found that fascinating because I have often talked on this program as an example, given the history of common laws, starting with the invasion of England by William of Normandy, right? William the Conqueror. That was 1066 AD. Charlemagne preceded him by a couple hundred years. So actually, I was wrong. Or at least I didn't go back far enough when explaining the concept of common law. The common law that arose from such a pre-global division of the earth could not be a comprehensive and coherent system because it could not be an encompassing spatial order. To begin with, there were primitive relations among clans, extended families, tribes, cities, vassalages, leagues, and counterleagues of all kinds. These functioned either at the stage prior to empire formation, or they were, as was the case on Italian soil until the formation of the Roman Empire, and on Germanic Roman soil until the formation of the Frankish Empire, part of the struggle in empire building. As soon as empires appeared on the scene, three types of relations arose: relations among empires, relations between peoples within an empire, and relations between an empire and mere tribes and peoples, such as those between the Roman Empire and the wandering tribes with whom alliances were forged and to whom imperial territory was entrusted. That's something to think about, some food for thought. With the rise of empires, you have these different orderings of people, these different alliances or relations between peoples or groups. When you think of globalism, the modern international order, post-colonialism, this drive for the conformity of the entire world to be under one world state, one world government, where we all have not just that we're speaking English, that the whole world has English imposed upon it, but that we're going to simplify it even more. And we're going to make a pictorial language so that we can talk in text message emojis. And eventually we can all talk in symbols that are beyond language, right? So that we will have one common global language. Well, when you think about that, and you think about the just countless tribal languages that have disappeared off the face of the earth, or even before that, the rise of empires such that Gaelic or Hebrew were extinguished. And these modern, Zionists basically brought back Hebrew by making Hebrew schools and insisting that their children learn Hebrew. Same thing with the Gaelic culture, the Irish and the Scottish making this Gaelic revival back in, I believe, the 19th century. Yeats was part of that in the 20th century, I know. The same thing, if you're asking me, I think the same thing should be done right now with Latin for all of us, so inclined to revive the Western civilization. But what he's talking about here, the rise of empires, well, and the extinguishment or the coming about of new relations between peoples, same thing is true of languages, of social structures. So he's talking about clans, tribes, vassalages, leagues. Where are those today? They don't exist. Now we have cities, we have counties, we have states, which are basically administrative divisions of a central federal government at this point, at least post-Appomattox. Where are leagues? Where are the clans? Nobody has clans. Even those of us who are Scottish, who talks about clans? We have clan get-togethers, clan wars. Those are done. We now have a global society. We're all members of planet Earth, right? The human race. International law among empires in the pre-global period contained some significant legal structures for war and peace. But, despite such initial advances, this international law could not overcome the lack of a global concept of the earth. It remained necessarily rudimentary, even though it established firm forms and accepted customs and diplomatic law, and alliances and peace treaties, and law pertaining to aliens, and an asylum law, because international law regulating relations between empires could not be converted easily into a firm bracketing of war, that is, into recognition of the other empire as a justus hostis. Consequently, wars between such empires were waged as wars of annihilation, until another standard developed. Law among peoples within an empire, however, was determined by the fact that they belonged to the orbis, or world, of the same empire. The territory of independent, autonomous confederates also belonged to this orbis. Conversely, even totally enslaved people, those robbed of all their land, still could retain their identity in terms of international law. This is demonstrated all the more clearly in a negative sense by the E4's annual declaration of war against the Helots in Sparta, that is, against the vanquished and subjugated people who had lost their communal fields. The idea of a coexistence of true empires, of independent Großräume, literally large spaces, figuratively large spatial spheres, and a common space lacked any ordering power because it lacked the idea of a common spatial order encompassing the whole earth. Thus ends chapter 2. I never really made a decision as to whether I wanted to start chapter 3 or just end the program early. See how long chapter 3 is. Yeah, too long to get done in 10 minutes, I'll tell you that. The Normans standardized the... let me X out of this. The Normans standardized the already existing Saxon law in England, says Padfa. Yes. Yeah, that's the my mistake, talking about the invasion of England by William of Normandy as though it were, the common law were some new development. Yeah, like I said, Charlemagne had already developed the common law. And I'm sure before him, that was not a new concept with the rise of Charlemagne, That's the thing about international law. It goes back to the dawn of humankind. You could study it the rest of your life and never get tired of it. Fascinating stuff. I think we'll do an early show today. Next time we'll talk about chapter 3, which is references to international law in the Christian Middle Ages. So like I said, he talks about the ancient world, which we just talked about. Then he talks about the Christian Middle Ages, which is still pre-global. This is before the discovery of the New World, before the conception of a globe, before the conception of our modern spatial order as we understand it, our modern consciousness. And he talks about how this concept in the Christian Middle Ages of international law at that time, and that spatial understanding, formed the basis for what we have now. So, without any further ado or further questions or comments, we will see you next Friday, same time, same place. Till then, everyone.